Okay, you are live, but you're not live web mode. Nobody else sees anything yet. You ready?
Hang on.
And once you start, I'm not talking no more.
That's fine.
You are finishing all the way through, and then once you're done, you'll just stop showing screen and mute your phone. That's all you'll do.
Sounds good.
Okay.
Ready when you are. Yep.
All right. In 3, 2. You're live.
Good afternoon. I want to thank you for taking time out of your busy day to join us. However, I think you're going to find the next 20 minutes of information very valuable. Let me introduce myself. My name is Dave Myers, and in addition to being an Ohio attorney, I have been in the technology field for the last 10 years. I am a co-owner of SpliceNet, which is a Cincinnati-based cybersecurity and technology firm. And what I've done is I've combined these two practice areas into my current legal practice, and now I spend my time advising small and mid-sized businesses where this intersection of law and technology happens. So that's pretty much where I focus the bulk of my legal work. Today, we're going to be talking about a new piece of legislation that just came out. But we're going to tell you a story. I'm going to tell it to you through a story. I want you to go ahead and I want you to meet Sarah. Sarah is an attorney. Sarah is an incredibly busy professional. Sarah wears a lot of different hats and spends her days juggling many various responsibilities. I'm pretty sure that the people on this call can identify with Sarah. And in fact, I think you would agree that one of the most important responsibilities she has is to retain the trust of her customers. Hey Jim, it says attendees still on hold, dude.
Dave, I'll check on that right away. I'll check on that right away.
All right. I'm going to click this start broadcast. I think that's what needs to happen.
The broadcast is now starting. All attendees are in listen-only mode.
Hello and good afternoon, everyone. I'm sorry it took a couple minutes to get things going, but we had a couple people join late. I want to thank everyone that's here today for taking time out of your otherwise busy schedule to join us. But I do think you're going to find the next 20 minutes to be really valuable. I will do everything I can to keep things to 20 minutes. We'll get you off here. If anybody has any questions or anything, you can feel free to ask in the question bar in the GoToWebinar control bar. And if you're having any problems connecting to the web portion, don't worry. We will be emailing a recording of this to all attendees. So if for some reason you can't get the GoToWebinar to work and you miss the web portion, you will still have access to it shortly. So what we're going to talk about today is a new piece of legislation, Senate Bill 220. This goes into effect November 2nd, and it brings some new protections to the businesses in the state of Ohio. Before we move into the content, let me explain why you might even want to listen to what I have to say. So my name is Dave Myers, and for over a decade, I have had a law practice as well as actively working within the technology field. I am actually a co-owner of SpliceNet, a Cincinnati-based cybersecurity and technology consulting firm, while I've maintained my law practice the whole time. And what I have done is coalesce those two things into my current practice, where I focus on advising small and mid-sized businesses in those areas where we find law and technology coming together. It's a very complicated area, and having had experience in both, I really have found an ability to work with speaking both languages, both text speak and legalese. Now, I only have 20 minutes of your time, so I'm going to jump right into the material, and I'm going to tell you a story today. I want you to meet Sarah. Sarah is another attorney. As a busy professional, she wears a lot of different hats and spends her days juggling many various responsibilities. One of her most important responsibilities is to maintain the trust of her clients. Without her clients, she would have no business. Sarah realizes that the basis of the attorney-client relationship is based on trust. Her customers trust her a lot. If they didn't, they wouldn't be customers in the first place, and they certainly wouldn't be handing over enormous amounts of sensitive data like they do on a daily basis. Sarah knows that even though this is very important and a huge benefit, it is also a huge responsibility. Her customers are freely giving her some of the most potentially sensitive information about them. By its very nature, this is important information, and they're expecting her to take the same level of care to protect it as they would take themselves. A failure to do that could be very troublesome. But Sarah also knows it's a dangerous world. There are hackers and thieves out there with the sole intention of stealing and reselling the information that her clients just entrusted to her care. And if that happens, Sarah knows that the consequences would be dramatic. She would likely face fines and penalties. She'd have to undergo an costly and time-consuming notification process to tell everybody that a data breach happened. She'd probably lose the trust of her customers and possibly the public at large, might receive some sanctions by the bar, and then at the end of it all, she's probably going to be facing some lawsuits from the people whose data was stolen. So in this world, what is it that Sarah can actually do to protect herself? She's consistently hearing cybersecurity, 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 without much of a definition as to what that means. Most of it is based on just fear tactics. And while the threat is real and she needs to be concerned, she's been looking for some real guidance. So what we have here is Senate Bill 220. And this gives us some guidance. It gives Sarah something to work with. It becomes effective November 2nd. And we know that it's going to give her some new protections, but we're just not sure what the protections are and how we're going to get them. That's what we're going to discuss for the rest of this presentation. So Sarah begins to dig into this new law. On the surface, it's pretty straightforward. There are some limitations. She learns first that the safe harbor is only from tort litigation. It's not going to do anything to protect her from fines, penalties, from government, regulatory bodies, any of that. It's also not going to take away the requirement to provide notification to governments and individuals in the event of a data breach. It's only providing protection from tort. Where? It would be any tort litigation brought either under the laws of the state of Ohio or in the courts of the state of Ohio. Well, this makes sense because it's just an Ohio law, but it's something that we need to keep in mind. And it only provides a defense when that tort litigation brought either under the laws of the state of Ohio or in the courts of the state of Ohio, and that tort alleges that it was a failure to implement reasonable information security controls, and that it was that failure that resulted in the data breach. So put another way, it's pretty straightforward. If Sarah is sued following a data breach for damages by the people whose data was stolen, and they say, Sarah, you didn't take reasonable security precautions, and that's why the data breach happened, and that's why we've been injured, and that's why we can sue you, Sarah can turn to the safe harbor, and she can say, no, I've met the requirements of the safe harbor, and so for purposes of the tort lawsuit, I have an affirmative defense that I can bring again, to defend myself. But what do we have to do to even start down this road? All right, on the surface, doesn't look too bad. First and foremost, we have to make sure that there is a written plan. It's not enough to simply say, we have a plan, we know our plan, we all talk about our plan all the time. It actually requires that it be written down. So what needs to be in this written plan? Essentially, we have to cover the three big types of safeguards. The first type of safeguard that needs to be included in the plan are administrative safeguards. Administrative safeguards include the appropriate policies and procedures that the company itself needs to have in place, both for the company generally, employees, contractors, vendors, partners, all these different groups. There are administrative controls that need to be put in place so that everybody understands what needs to be done to protect the data. The second type of safeguard are your technical safeguards. Technical safeguards are, not surprisingly, involving the technology behind protecting the data. We're talking about things like firewalls, intrusion prevention, intrusion detection systems, antivirus, and more. Now, Sarah realizes that she's probably going to need to get a dedicated cybersecurity technology company to get involved to figure out what's available, what makes sense, what she can afford, and then to help her implement it as necessary. In addition, technical safeguards also include the policies and procedures that are related to the technology to make sure that it's up to date and running and doing what it's supposed to. Finally, we have physical safeguards. Physical safeguards are basically about the physical items. So Sarah looks around her office and she can see several areas where she's going to have to implement some additional physical safeguards. One, she needs to make sure that access to her to the desk, to the endpoints is restricted. People can't just sit down and use them. Have to make sure that the server is locked up and preventing people from just coming in and physically accessing it. The point of physical safeguards are twofold. One, to make sure that the data is protected in the event that there's a natural or environmental hazard, as well as to prevent against unauthorized intrusion. So Sarah's got to make sure that the physical facilities and that the surroundings are all conducive to those different purposes. It's going to take some work. So it's not as clear as it seems on the surface. But the question then becomes, we've got three safeguards. What do we need to do? What are they safeguarding against? First, the written plan needs to ensure that the data is secure and retains its confidentiality. In other words, the safeguards need to keep the data from getting out there into the wild. Secondly, the safeguards need to be designed to prepare and protect from anticipated threats to the security or integrity of the data. It doesn't have to cover every possible random scenario, but if there's an anticipated threat, something that Sarah can reasonably believe could happen, then the safeguards need to be prepared to protect against that. Finally, it needs to protect against generally just unauthorized access or acquisition. This is different than the security and confidentiality, although it is related. This is to make sure that, to put it as clearly as possible, people that should not have access to the data don't have access to the data. So this all sounds good, but how far do we need to go with this? It doesn't do much good to spend all this money to mitigate a risk if the actual damages that ignoring it would be less than the cost of avoiding it. Obviously, if we had unlimited resources, we would go ahead and throw every safeguard in place that we possibly could. But the reality is that we don't have unlimited resources. We have to dedicate and we have to ration our resources, and it has to make sense. The statute provides several factors to weigh in determining how expensive your written program needs to be. First of all, it takes into account the size and complexity of the entity involved. The larger and more complicated you are, the more you'll probably need to have in place in order to properly protect your data. Secondly, you need to look at the nature and the scope of the activities of the entity. What this means is how closely related to the control and scoring of this data is the everyday activities. If it's highly related and integral to the activities of the business, you're probably going to have a higher threshold than if you're just tangentially collecting some minor sensitive information in a small relationship. Third, we've got to look at the actual level of sensitivity of the trading. There's a big difference between first name, last name, and email versus first name, last name, email, address, social security number, bank account number, bank routing number, and a whole slew of financial information that is much more likely to give rise to fraud and fraudulent activities. So the more sensitive the information is being collected and retained, the more extensive the program should be. Next, that gets weighed against the cost and availability of tools to actually provide the protection that we're putting in place. So first of all, we can't put in a protection if the technology to do so doesn't exist. Secondly, we realistically can't put a protection in place if the cost of doing so is unreasonable and unachievable for an average business. Finally, we look at what resources are available to that particular business. What that means is a larger business with vast resources might have a higher expectation to go further in their efforts than a small business that doesn't have nearly as much to invest in their own cybersecurity. These 5 factors, there's no predictable formula. There's no given formula. It basically just says weigh all these different factors. And so that doesn't really help us either. So we're sitting there and we're going, okay, so what guidelines can I actually use? Rather than provide a list of what you're supposed to do within the statute makes references to external frameworks, best practices, etc. It lists a number of frameworks and then says that if you reasonably conform with one or more of these frameworks, then you meet the requirements to exercise the affirmative defense found in the safe harbor. Great. So out of all these frameworks, which one should Sarah choose? It doesn't tell you in the statute. It just gives you the list. And there's no decision tree available. So let's go through and let's look real quick at the options that are available. You've got the NIST framework for improving critical infrastructure cybersecurity. And this is providing standards, guidelines, and best practices. It is based on a prioritized, flexible, cost-effective approach. It's very reasonable for businesses of all sizes to work with this. Going up the chain with NIST, we have 800-171. That's a special publication, 800-171. This is focusing on controlled, unclassified information in non-federal systems and operations. This is going to be a slightly higher standard than the critical infrastructure cybersecurity standard above. Continuing, it also lists NIST 853 and 53A. These two are related to each other, and they provide the requirements for federal information systems. So that's when we're getting into a much more highly controlled, much more sensitive natured data. It is also going to have a much more complex implementation requirement than the critical infrastructure cybersecurity or even 800-171. Statute also lists FedRAMP, which is basically government-wide guidelines on information security and system security for government systems. This is separate from NIST, but it also provides a set of guidelines. It is pretty strict, more so than the ones above it, but maybe not as much as the NIST 853. Veering from all these guideline-based ones, we're going to go ahead and look at the Center for Internet Security, Critical Security Controls for Effective Cyber Defense. And yes, that is actually what it's called, and it's very different than the ones before it. Instead of talking about guidelines and best practices and standards and flexible, it goes through and it says, here are a list of 20 high payoff items, focused actions that you can take that will allow you to mitigate most of your risk just by taking these. It's essentially the low-hanging fruit approach. Finally, we have ISO 27000, Information Security Management Systems. Again, this is more of an international ISO stuff. It is a top-down, risk-based, technology-neutral approach, very similar to the ones above, with the exception of the critical security controls. If you happen to be in a regulated industry, the statute also provides some options. So, for example, if you are in the healthcare field and you have protected health information, you would probably already be complying with HIPAA and HITECH. If you can show that you're complying with HIPAA and HITECH, the safe harbor would then apply. Similar situations exist for financial institutions with Gramm-Leach-Bliley and government information with FISMA. This is great. So now we have 10 different frameworks. We have 5 factors. We have 3 types of safeguards, and all of this has to be in a written plan. Now, we're obviously better than we were, but what is the next step that SARA needs to take? Basically, there's a 5-part assessment process that SARA needs to go through. 1, you need to go through and you need to look at your data first. You need to conduct an inventory of the data. It is not reasonable to decide which framework you need to play by and what your requirements are until you know what kind of private data you even hold. Secondly, once you've got that in hand, you need to go through and you need to think about what your actual exposure is. Now, most of this is going to be based off historical data and estimations, looking at, analogs, and it's not going to be perfect, but it's just like any exposure calculation. It has to be done. How much do we stand to lose if this data is breached? Once we know what we have and what our potential exposure is, we got to do our gut check. This is that moment to say, how much risk am I actually willing to take? Different businesses and different business owners will have different opinions on this. They will have different risk tolerances. And so we might reach a different outcome by someone who's willing to take more risk than someone who's not. If we've decided to move forward at all, the next step is to look at framework evaluation. This is where we go through, we look at our data, we look at our risk tolerance, we look at our budgets and all that good stuff, and we decide, hey, this is the framework that makes the most sense and is most related to my business. So we're going to look at the requirements of that framework and see where our present state is, where our desired state is vis-a-vis that framework. And now we have a rudimentary roadmap. Finally, once we have that roadmap, only then can we make that decision on whether or not to proceed with the next step. Because at that point, you've actually got we're going to do X and Y and Z, which is based on my specific data for my specific industry, based on my specific liability exposure and my risk tolerance. It's only when you have those other 4 pieces together that you can sit down and actually make that go, no-go decision on whether or not to proceed with the next step, which is actual implementation, execution, and monitoring of that plan. Now, I'm coming up on the end of 20 minutes, and I want to go ahead and invite anyone who has any questions to feel free to email me. I am at david@djmyerslaw.com. You should all have that email address from the invites. Any questions? I will be sending out a recording of the session to everybody involved. And if anyone would like to talk about this assessment process, I'm happy to have a phone call with anyone to just walk them through what their assessment would what their initial assessment would probably look like, and decide if they should be taking the next step and actually conducting that assessment. So that's really all I have for today. I've kept it right around 20 minutes. I appreciate you all for taking the time, and I hope you have a great day. Bye now. everyone. I want to thank everybody for taking time out of your busy day to join us. I do think you're going to find today's information really valuable, though. I'm here today to talk to you about a new law that sorry about that. Good afternoon, everyone. I want to thank you for taking time out of your busy day to join us. I think you're going to find the information that we're going to talk about really valuable. What we're here today to talk about is the new data privacy safe harbor that's provided in Senate Bill 220 and what it means for you and how to get started with it. Who am I? My name's Dave Myers. I am an Ohio attorney and a co-owner of SpliceNet, a Cincinnati-based cybersecurity and technology consulting firm. And I've been doing both these things for the last decade. What I've done from a legal perspective is focused my practice on advising small and mid-sized businesses among many different areas where law and technology meet. A big part of that is in the cybersecurity and data privacy world. So of course, when a new law comes into effect, such as Senate Bill 220, I feel it's important for us to go through and gain some familiarity with it. I only have 20 minutes of your time, so I'm going to just jump right into the materials. I promise to keep it under 20 minutes. If you're in the session and you have any questions, feel free to use the questions section in the GoToWebinar bar. And if you happen to be connected by phone but are unable to join the webcast, don't worry, we are recording it and we will send it to everyone after the session is complete. So, having gotten that housework out of the way, let's get going. I want you to meet Sarah. Sarah is busy. She's a busy professional. And just like all busy professionals, she tends to have a lot of different responsibilities coming at her every single day. One of the most important responsibilities she has is to maintain the trust of her customers. Let's face it, without customers, there's no business to have. Sarah realizes that her customers value her and trust her a lot. If they didn't trust her, they wouldn't be her customers in the first place. And they certainly wouldn't be handing over the enormous amounts of sensitive data that they do. Sarah knows that along with this significant level of trust comes a huge responsibility. Sarah's customers are giving her some of their potentially most sensitive information. We're not talking about basic info. We're talking about potentially things that they would not share outside of their own four walls. And this stuff is so important that they would expect Sarah to take the same level of care in protecting it as they would. But Sarah knows that there are a lot of people out there. It's a dangerous world. There are hackers, there are thieves, and they're out there with the sole intention of stealing and reselling this very sensitive information that Sarah has in her possession. Sarah also knows that if she fails to properly protect the data, the fallout could be devastating. She would probably face fines and penalties, both from the state and other regulatory bodies. She would usually have to engage in costly and time-consuming notification to both government entities and the people whose data was breached. She would probably lose the trust of her customers and possibly the public at large, and any professional licenses that she has could be called into question. At the end of all that, she's very likely to find herself on the bad end of a lawsuit claiming damages by the very people whose data was stolen. As I said, this is a bad outcome for Sarah. So what can Sarah do to protect herself? She hears things constantly about cybersecurity, but she doesn't seem to ever get a clear direction on what she's supposed to do. Finally, with Senate Bill 220, we're at least getting a little bit of protection and a little bit of direction. So Sarah heard about Senate Bill 220. She knows it becomes effective November 2nd, and she knows that it's going to provide her some new protections. But as of right now, she's not quite sure how it's going to help her. So Sarah begins to dig into the new law. The first thing that Sarah learns is that the new law only protects her from certain liabilities. This safe harbor only applies to tort litigation. It does not provide a safe harbor from fines, penalties, or other notification requirements that are following a breach at either the state or other regulatory agency level. It is simply a defense, an affirmative defense in tort. Because it is an Ohio law, jurisdictionally, in order for the safe harbor to apply, it has to be brought either under the laws of the state of Ohio or in the courts of the state of Ohio. And the suit that is brought under the laws or in the courts has to allege the following. It has to be based on this concept that a failure to implement reasonable information security controls were the cause of the data breach. It is what resulted in the breach. So when you have this situation, when you have a tort lawsuit brought under the laws or in the courts of the state of Ohio, claiming that a failure to implement reasonable information security resulted in the data breach that the lawsuit is based on, it is in this instance when the safe harbor can be used. So, having looked and realized that this is out here, the next question is, what do we have to do? Sarah starts going through and making some notes on the requirements of the safe harbor, and on the surface, it doesn't look too bad. First of all, she needs to have a written cybersecurity program. She can't just say, oh, we all know what we would do. We talk about it all the time, and we even practice. No. Under the statute, it needs to be written. And it needs to contain certain things in this written plan. Sarah comes across this idea of safeguards. Turns out there's 3 of them. The first type of safeguards that the plan has to contain are administrative safeguards. Administrative safeguards are the appropriate policies and procedures that the company, employees, contractors, partners, vendors all need to follow to ensure. In other words, this is how people need to conduct themselves. And these are the policies and procedures that state as such. The next type of safeguard are technical safeguards. These are, not surprisingly, based on technology. These are things like firewalls, intrusion detection systems, antiviruses, and other technological defenses. It also includes the appropriate policies and procedures that are part of the technology to make sure that they are updated, running properly, and doing what they're supposed to do. Sarah recognizes that she'll probably need to call in a cybersecurity company to help determine what technologies are available, as well as to help implement them. The third type of safeguards are physical safeguards. These are things such as protecting the physical assets that control the data from natural and environmental hazards. This would include having backups of the data, having redundant means of accessing the data, so that the data is safe and its integrity is protected. It also means having appropriate physical safeguards to prevent someone from engaging in authorized intrusion. They can't just sit down and get to data that they shouldn't get to. Now that Sarah's listed her 3 types of safeguards, what do the safeguards have to do? The safeguards need to do 3 things. They need to protect the security and confidentiality of the data. This means that it keeps that data from going out into the wild. It keeps it safe, it keeps it confidential, it keeps it from going out to unintended parties, unintended disclosure. It also has to protect against anticipated threats and hazards. This doesn't mean that Sarah has to protect herself against every wild, imaginable, possible scenario. But if there's something that can be reasonably anticipated as a threat or a hazard to this data, your safeguards should be put in place to protect against them. Note that the statute also states that it's threats and hazards to security or integrity of the data. So this would be more than just the data going to a third party. It would also be making sure the data stays the way it should and isn't subject to corruption, tampering, modification, etc. The third thing that safeguards need to do is they have to protect against unauthorized access or acquisition. This is related to, but slightly different than the security and confidentiality prong. Security and confidentiality is making sure that we're not letting things get out into the wild and that things stay confidential. The unauthorized access or acquisition is making sure that people that shouldn't have access to the data don't. So Sarah's thinking to herself, this sounds great. I need these safeguards. I need them to do these things. But where on the continuum do I really need to take this? How much do I really need to do? I mean, if it's going to cost me more money to implement this program, then I would be subject to liability under a lawsuit. It just doesn't make it worth it to me. Now, yeah, if Sarah had unlimited resources, she's a good person. She'd probably put every safeguard she could think of in place. But that's not realistic in the real world. Sarah has limited resources, and so she has to really prioritize her dollar spend. And so if she's going to make this effort, it has to make sense. So how do you determine the extent that your written plan has to go to? Statute does not lay out a specific extent, but what it does do is give us a 5-factor review process. The first factor that we look at is the size and complexity of the entity involved. The larger and more complex the entity, the higher we presume the standard will be for how complex and comprehensive the plan needs to be. The nature and the scope of the activities of the entity. This one will presumably be related to, does the activities, the normal everyday activities of the business, how closely are they tied to the sensitive data in question? Is it something where the sensitive data makes up a core component of the activities of the business? Or is it something minor that they only tangentially get periodically? That'll make a difference. The third item to view is sensitivity of the information. This is the question of, do we have a first name, last name, email address? Or do we have first name, last name, email address, physical address, social security number, bank account number, and all that stuff is being held by the business? Obviously, the more sensitive the data held, the higher standards are going to be held too. These are typically weighed against the cost and availability of security tools. In other words, if the technology doesn't exist to protect against this kind of a breach or to protect this kind of data that's held in this way, then there's nothing you can do about it. It also means that just because the technology exists, if it's cost prohibitive, then perhaps that's not going to be necessary. Finally, we also are to look at the resources available to the entity. How much money does the company have? How many assets are available to the company right now to implement this plan? It doesn't mean that an impoverished company has no responsibility, but the more resources available to protect the data, the higher the standard is likely to be. So we now know what the 3 safeguards are. We know what they're trying to do. And we know the 5 factors that we're going to look at in order to determine how extensive the plan needs to be. But what are the specifics to the plan? There's no specifics in the statute. It doesn't list out you need to do X, Y, and Z. Instead, it references external standards. It references several different industry-recognized cybersecurity standards and says that if you reasonably conform with one or more of these, and it meets the criteria discussed earlier, then were written at different times, have been updated at different times, and are targeted at different audiences. Because of this, some of the frameworks are far more complex than others. And of course, Sarah is not familiar with all the technical frameworks and their details, so she's got to start by thinking about which one even matters. So here's a list of them. The first is the NIST framework for improving critical infrastructure cybersecurity. This is a pretty industry independent standard guideline of best practices approach. Its focus is on cost effectiveness. NIST 800-171. This special publication is laid out for controlled, unclassified information in non-federal systems and operations, and it tends to be more strict than the Improving Cybersecurity Infrastructure Plan. NIST 800-53 and 53A take it even a step further and is more strict because this deals with federal information systems. FedRAMP is yet another one that's listed, and FedRAMP is the general principles, best practices, and standards that for government-wide systems, okay? Not just federal, but all government-wide agencies. Next, we have the Center for Internet Security, Critical Security Controls for Effective Cyber Defense. Try saying that 5 times fast, you can't do it. But this one is very different than the others because it actually provides a recommended set of targeted actions. These are the high payoff actions. These are the low-hanging fruit. This is saying you do these 20 things and you're going to have a significant improvement in your cybersecurity. Finally, ISO 27000. This is an international one. Again, we're back to our top-down, risk-based, technology-neutral approach. So what about if you already have regulations? What if you're a healthcare provider? You've got protected health information, or you're a financial institution subject to Gramm-Leach-Bliley, or you're a government entity that's subject to FISMA. Well, the statute says that if you're in one of these industries and you need to comply with these other statutory regimes, then reasonable compliance with them will also give you the benefits of the safe harbor. So at this point, Sarah has gone through and determined what she thinks is all the core information that she needs. What does she do next? The next step is what I call an initial assessment. She needs to go through. She needs to make sure she understands all the data that she has in her possession. Only once she understands the data that she possesses will she be able to determine what kind of exposure she has, what statutory and other regulatory regimes is she subject to, and what do breaches of that kind of data typically cost in a lawsuit. Next, Sarah has to look at her risk tolerance. This is that gut check. This is saying, are you a risk taker? How much are you going to spend to avoid that risk? Or are you comfortable letting it ride? And when the data breach happens, you're comfortable with the fallout. Once we've looked at the exposure and the risk tolerance, we can then match it up to the appropriate framework. We can figure out, do you need to comply with one of the more complex ones, or can we go with a lower complexity one based on all the 5 factors that we looked at earlier, as well as the data that you hold? finally, once we've done all this, and we know how much it's going to cost, and we know what we have to do, only then can we make that go, no-go decision on whether or not to implement this new cybersecurity program that would then enable her to take care and take advantage of the new safe harbor. We're right on 20 minutes right now. We have covered all of what I consider the fundamentals of this statute. If you have any questions, give me an email or a phone call. Also, be aware we're going to be sending an email out to all the attendees. We will be sending you a copy of the recording, and we will also be sending a simple one-question survey as to whether or not you found the information valuable. Thank you, and I hope everybody has a great day. Bye now.